Okay, so apparently I still don't fucking understand this, even though I've read it a million times. Trial, jury, discharge, and replacement by alternate juror. If a juror engaged in misconduct of a substantial nature or is grossly unqualified to serve in a case, but not warranting the declaration of a mistrial, the court must discharge such juror. If an alternate's available, the court must order that the discharged juror be replaced. And wait, I fucking already know this. Okay, if the trial jury has begun its deliberations, the defendant must consent. Everybody knows that, right? Such consent must be in writing and must be signed by defendant in open court, in the fucking presence of the court. If the discharged juror was a foreperson, the court shall designate the new foreperson, the juror whose name was second drawn and called. Why do they have to say he has to designate? Why can't they just say the fucking second juror is the fucking new foreperson? And then if no one's available, they must declare a mistrial pursuant to subdivision 3 of 21080, which is that it's physically impossible to proceed in conformity with law. And the parties get an opportunity to be heard before discharging a juror. If the court discharges a juror, it places on the record the facts and reasons its determination that the juror is ill, incapacitated, or unavailable for service. Nothing in this section shall affect the requirements of subdivision 1 pertaining to discharge of a juror where the trial jury has begun its deliberations. And then it's got to be in writing, the fucking consent. Alright, next issue. Motion for a mistrial, which I fucking read. At any time during the trial, the court must declare a mistrial and order a new trial of the indictment under the following circumstances. 1. Upon motion out of the defendant when there occurs during the trial an error or legal defect which is prejudicial and deprives him of fair trial. 2. Upon motion of people inside or out the courtroom when there occurs during the trial gross misconduct by defendant or a person on his behalf or a juror resulting in substantial and irreparable prejudice to the people's case. 3. Upon motion of either party or sua sponte when it is physically impossible to proceed with the trial in conformity with law. 280-20, motion for mistrial, status of indictment upon new trial. Upon a new trial resulting from an order declaring a mistrial, the indictment is deemed to contain all the counts which it contained at the time the previous trial was commenced, regardless of any count was dismissed by the court prior to the mistrial order. Okay, so that's what it fucking says in 280.20. Now, in 310.60, it says, discharge of jury before rendition of verdict and effects thereof. 1. A deliberating jury may be discharged by the court without having rendered a verdict only when, and there's 3 reasons. A. Extensive deliberation without a verdict and it's unlikely in a reasonable period of time. B. Everyone consents. Or C. A mistrial is declared. And then it says, when the jury is so discharged, the defendant or defendants may be retried upon the indictment. Upon such retrial, the indictment is deemed to contain all the counts that it contains, except those were dismissed or were deemed to have resulted in acquittal pursuant to sub 1 of 290.10. So now I have to go to 290.10. What the fuck? Trial order of dismissal. At the conclusion of the people's case, or at conclusion of all the evidence, the court may, except as provided in subdivision 2, upon motion of defendant, A, issue a trial order of dismissal. That would dismiss a count on the ground that the trial evidence is not legally sufficient to establish the offense charged therein or any lesser included offense, or B, reserve decision on the motion until after the verdict has been rendered and accepted by the court. If the verdict is guilty, the court shall then proceed to determine the motion. It had not reserved decision. If it determines that a motion should have been granted, it shall enter an order both setting aside the verdict and dismissing any count of the indictment upon such grounds. If the jury is discharged before the rendition of a fucking verdict, the court shall proceed to determine the motion as set forth in this paragraph. Despite the Oh my God, I can't even fucking deal with it. So, if the jury is discharged before rendition of a verdict, the court shall proceed to determine the motion as set forth in this paragraph. And that's why the fucking answer is F.